Good evening, everyone. Welcome to today's Indian's Forensic Psychiatry program. Today, we have with us Dr. Vinay B., who is consultant psychiatrist at NIMHANS. After his MD, he has done postgraduate diploma in medical law and ethics, postgraduate diploma in human rights law from National Law School, India University, Bengaluru. Today, he'll be discussing on civil responsibilities. We welcome you for today's presentation, sir. The outline of his presentation would be as follows.
What are the responsibilities and how it's relevant for medical practices and why it is needed. Then focusing on differentiating between the civil law and criminal law, and looking into the various interface between person with mental illness and law. Then further going into the specific aspects, the civil responsibility with regard to person with mental illness. So with this, I would be starting my presentation. So when we look into the what do you mean by medical law? So it is a body of law concerning with the rights and responsibility of the medical professional and their patients. So they mainly focus on the medical law is on the confidentiality, negligence, and various fraud related to the medical treatment, and also various criminal laws and ethical guidances. So as we know that various rules, regulations apply to the our day-to-day medical practices, and where they come is the question. So when we look into the source of the law, it can be like various enacted legislations, like case laws, or even the international frameworks with regard to the person with mental illness. There are various enumeration of the laws. In absence of any laid down laws, even the judgment given in a ruling can also be taken as in law, which is called as a case law, where various enumeration with regard to case laws. Now, coming into the duties of clinical care in the medical practices with regard to the rights of patient, corresponding duties of care applies to all the patients, which can be categorized into three aspects. That is the protection of life and health, autonomy, and fairness and justice. When we look into the protection of life and health, it's the standard of care, not causing any untoward harm or suffering to the clients. And with respect to autonomy, there are various attributes like ability to reason, plan, and make choice. As a professional, we need to respect them, and especially with regard to the consent and confidentiality. If such things are not being valid and given priority, that can rob the dignity of the patient. So now moving on to the justice and fairness, it's mainly with regard to the access to and the quality of clinical care, which should be based on the need base rather than the favoritism. And injustice can prevail if there is based on the socioeconomic status or attraction or professional. So now, with regard to injustice can occur through treating patients unequally according to their economic background or attraction or professional or age and race. So basic will be equal access to the appropriate care according to the need should be done. As professional, why we should take this as a seriously? Because as we know that there are various laid down procedures and protocol. One would be the professional regulations and also various laws which are being there in constitutions and statutes. And as doctor may be sued in civil law for financial compensation for a failure in the professional duty which leads to any injury. If that harm or injury is intentional, then it will be taken for a criminal law basis. So now coming into the, is this necessary for medical practices? When we look into this one, there are two aspects which is important. That is, the law serves to demarcate the limit of individual autonomy in the interest of society. Second thing is that it also protects the rights of individual. So here it's most important is that as being at a higher authority, there may be chances of professional misusing or crossing the line. So with that regard to that one, it serves a demarcation like protecting the individual autonomy and also right. And as we are aware, under contract, if we are seeing any patients, we are bound to giving treatment, and we can't refuse treatment if we are under contract. And every doctor, whether they like or they don't like, they should be fulfilling certain legal requirement in giving medical services as defined under a law. So having a good understanding about the law coupled with good what you call practical way of dealing with that one would definitely help in dealing the what you call overcoming the fear of law. So now, when we look into the legal aspect of medical practices, that can be cover two areas of medical law. One would be the medical jurisprudence, which deals with the legal aspect of medical practices, and second one is the forensic medicine, which deals with the medical aspect of the law, which we'll be defining later. So now, also looking into the ethics and the law, law is influenced by ethics and to some extent the converse. So obviously, important thing to comply with the law, but law says may not be ultimate answer into like with regard to moral questions. So as we are aware that there are various codified law which are derived from our ethical practices. For example, the Marriage Act, which has been there. So now, as we see, is that the basic domains of ethics would be like beneficency, autonomy, justice. So when we look into that, where there is a deficiency in any domain can be leading into the coming of the law. For example, if autonomy is not being respected or not taken into consideration, the consent can lead into assault or battery, or autonomy is not there, confidentiality or justice is not prevailed, there can be a discrimination. So there is definitely a link between both. So now moving into the specific aspect. So what do you mean by forensic psychiatry? As we are aware that it's a branch of psychiatry that deals with issue arising in interface between psychiatry and law, with flow of mental disordered offending along the continuum of social system. So with this background, we will be first looking into the what is the difference between civil law and criminal law. So as per definition, the criminal law is a body of law that deals with the crime and legal punishment of a criminal offense, whereas civil law, it deals with the dispute between individual, organization, or between two, in which compensation is awarded to the victim. So when we look into the purpose, the criminal law is to maintain the stability of the state and society by punishing the offender and deterring them or others from further occurrence of such incidents. Whereas the purpose of civil law is to settle the dispute between two individuals in which compensation is awarded to the victim. And in civil law, it's been by the private party, which is a case filed, and it's between two individuals or two organization. Whereas in criminal law, it's against the state. So when we come into the standard of proof, which is required in criminal law, is always beyond a reasonable doubt, whereas in civil law, it's a preponderance of evidence. Claimant must produce evidence beyond the balance of probability. When we go into the burden of proof, the prosecution must prove defendant guilty in criminal laws. As in civil law, claimant must give proof. However, burden may shift to the defendant in situation like res ipsa loquitur. Now, coming into the outcome of the cases, the civil law is mainly focusing on the compensation depending upon the injury or damage occurred, whereas in criminal law, the can be either custodial, like imprisonment, or non-custodial punishments, which can be compensation fines or community services. So, with this background of this one, now we will specifically move into the tort law. So, civil wrong committed by one individual against another, which a person fails to take a proper care that results in the damage, is what basically we can define as a tort law. When we further move into the categorizing tort law, especially related to medical practices, it can be like intentional tort or unintentional. Unintentional would be further like negligence. In intentional tort, it can be assault, battery, or false imprisonment or invasion of privacy. So, like when we understand assault is a threat or attempt to do a physical harm, whereas battery is an act that results in harmful or offensive physical contact. False imprisonment is the limiting of someone's liberty or freedom without authority or right to do so with the laid down laws. Invasion of privacy, the act of going into someone's personal life or becoming involved in a situation where one is not permitted. So now when we further look in with respect to medical practices, treatment without consent can amount to assault and or battery. So with regard to the private tort law, doctor can be sued and result can be in the form of compensation fine. And the best defense against such would be like having a valid consent both from patient and proxies, and exemption as granted by the laws, especially in case of emergencies or in the case of a disaster where there is no need of the waiver of the consent can be considered. Now, moving into negligence, first thing we should understand that as depicted in the Bolam test, so we should look into the whether there is a duty of care existing. First thing is that there should be a duty of care we should be prevailing, then followed by whether there is a breach in the duty of care resulting in injury is the important things. It's not just a breach of the care, it should be resulting in direct into injury. So in such cases, private law can come into there where doctors can be sued for negligence, and plaintiff has to establish if breach of duty caused the injury. The resulting outcome can be in terms of compensation in civil laws, depending upon the pain, suffering, or future loss incurred. So if any manslaughter is noted, then the criminal law will be coming into action. So now moving on to the aspects of interface between the law and mental illness, it can be categorized in three aspects: criminal responsibilities, as already covered, the civil responsibilities, and issues related to curtailing of liberty during admission and treatment. So here, as we see the slides, with regard to curtailing liberty, mainly focusing on treatment, it will be in terms of admission, treatment, discharge, follow-up, and even community treatment, and right of a person with mental illness. So we are not going to this aspect, and this is well covered, especially in the recent enacted Mental Health Care Act of 2017, especially focuses on the person with mental illness in admission, setup, and community treatment. Now moving on to the other criminal, this one mainly focuses on two aspects, that is criminal responsibility, McNaughton's laws, and fitness to stand trial. So this has already been covered. Now coming into the main domain, civil responsibilities can be with respect to testamentary capacity, marriage, divorce, guardianship, fitness to duty, and management of property with a person with mental illness. Now, before going into the domains of civil responsibilities, defining what civil law. So it's a body of rules that protects the private rights of a citizen, offers legal remedies that may be sought in a dispute, and covers area of law such as contract, torts, property, and family law. So when we see into that, especially with regard to the medical practices, especially with person with mental illness, the civil law, it revolves around factor which determines the capacity to perform a particular functions. So overall, professional would have been sought in for legal remedies, mainly with respect to the capacity of a person to perform a particular functions. So now when we look into the what I mean the capacity is the individual psychological abilities to form a rational decision, specifically the individual ability to understand and appreciate and manipulate the information and arrive at a rational decision. So these are the four aspects which should be considered when we are assessing capacity. Now, specifically now coming into the laws, civil laws which are related to the person with mental illness, there are various laws pertaining to person with mental illness. So one such would be marriage and mental health registration, various law related to marriage, divorce, which we will be discussing in the coming slides, and Family Court Act of 84, Indian Evidence Act of 1925, Law of Contract, and Representation Act of People, and Indian Succession Act, which predicts about testamentary capacity. So now coming into the first domain of the interface, like where testamentary capacity, in the basic sense, it's the ability to make a valid will is the testamentary capacity. So which is being depicted in the Indian Penal Code section 31, will denotes any testamentary document. So when we look into the Indian Section Act, Section 2, Testamentary Disposition, Act defines will as a legal declaration of intention of a testator with respect to his property, which he desires to be carried into effect after his death. So when we look into the tests for determining whether a person possesses the capacity is well established in a case of Banks versus Goodfellow, where the court laid down four broad criteria. So first would be whether the person is able to understand the nature of the act and its effects, along with able to understand the extent of property at his disposal, and be able to comprehend, appreciate the crimes to which he is out to give. And the last point, which is main important, is that with a view to the latter object, that no disorder of mind shall poise his affection, prevent his sense of right, or prevent the exercise of his natural faculties. That, for example, that no insane delusion shall influence his will in disposing of his property, like bring about a disposal of it if the mind had been sound, would not have made such decision. So broadly, that person who is going to have the testamentary capacity will to be made should be able to understand what is the nature of the act and how it's going to affect, and what is a disposable property, how much he has, and whom he's going to divide into is that, and what is the rationale behind that one. And especially the psychiatrist would be sought out for assessment mainly with regard to whether the person has the mental illness, and if he has the mental illness, whether his symptoms, especially like delusions or any other things, is influencing on his decision making capacity. So now moving on to the other domain, the contracts. So is dealt in the Indian Contract Act of 1872 in section 6, 11 and 12, which I will be explaining in the next slide. So when we look into what do you mean the contract is an agreement which should be enforceable by law. So if it's not enforceable by law, it can't be considered as a contract. And in simple terms, agreement is the proposal which is being accepted by the both parties. So when we look into the, especially with regard to person with mental illness, the Indian Contract Act in section 6 says that a proposer is revoked by death or insanity of the proposer. Section 11 says that every person above the age of majority and of a sound mind is competent to contract. So section 11 clearly says that they should be of a sound mind to contract to be valid. So section 12 says that at time of making a contract, if a person is capable of understanding it and of forming a rational judgment as to its effects, then it's considered to be of sound mind. So how sound mind is defined is that when there is a person is able to understand and form a rational judgment, then they can be considered in the sound mind. So now looking into is that at the time of making a contract, either party is of unsound mind and the other party is aware of that one, and it shows that there is a slight advantage is taken of that one, then the contract would be invalid. Now looking into the other aspect where the party is unaware of the fact of a person of unsound mind, but if the contract is fair one, then the contract can be considered as valid. Like insanity which develops subsequent to the contract does not make it invalid unless steps are being taken for its resolution or performance of service becomes impossible. So now as most of us would be very well aware of with regard to consent, as we would be taking consent in the most of the intervention which we are doing. So in Indian Penal Code section 90, it defines says that if a consent is given by a person who from unsoundness of mind and or intoxication is unable to understand the nature and consequences of that to which he gives consent, then such consent is invalid. So here also same resounding of unsoundness of mind. So the capacity which is comes here. So a person of unsound mind does not understand the nature and consequences of an act, so is incapable of giving a valid consent. So any consent person with mental illness is given in the lucid interval is valid, and the person is binding on should be binding on the contract. So now moving on to the another aspect, that is marriage and divorce. So the family law is a branch of civil law that deals with marriage, child custody, adoption, and any other related to family issues. Here, one important thing we should understand that in this branch, especially the civil law for family law, that there is no necessarily that there should be a civil wrong should be committed. So that is one of the important thing. And depending upon the various practices, the various acts have been enacted, the Hindu Marriage Act of 1955 with amendments, the Parsi Marriage Act, the Christian Marriage Act, and Special Marriage Act of 1954, and the Family Court Act of 1984. So now when we look into the Hindu Marriage Act and the Special Marriage Act, the marriage between two parties is valid only if at the time of the marriage neither party is incapable of giving a valid consent as the consequences of mental illness, or though able to give consent, but he's being suffering from an mental illness of such kind and extent that he is not able to fulfill the obligation of the marriage. And third point which has been noted is that has been subjected to recurrent attacks of insanity or epilepsy, which is being elaborated in section 5 of the act. So here overall is that the parties, both parties should be having like because of mental illness, they should be not like the consent capacity of the giving consent should not be impaired, and they should be, even though having mental illness, if they are able to fulfill the obligation of marriage, then the marriage would be considered valid. So now when we look into the section 13, which describe our divorce, in Hindu Marriage Act, a person can sought a divorce if a partner is suffering from a mental illness to such extent that he is not able to fulfill the obligation of marriage for 2 or more years. And here there are two more factors which need to be considered, is that whether there was attempt to treat the person, and the response to the treatment also plays a crucial role in determining the outcome. So that was with regard to Hindu marriage. Now moving on to the Muslim Marriage Act. To marriage to be valid, both parties should be legally competent. That is, they should be adult and sane. Second thing, the person can seek divorce on the ground that partner has to be mentally ill for more than 2 years. So even the recent act, like male can be given talaq orally, that has also been squashed in 2019 Act amendments which have been made. Now, with respect to Christianity, nullity can be taken on the 5 grounds, out of which lunacy is the one of them. And for dissolution of the marriage, unsoundness of mind, which is incurable and present for 2 years. So now I was talking nullity of marriage and divorce. So first we should understand that nullity of marriage is based on the validity of the per se of the act, that is marriage. Whereas divorce is then dissolution of an valid act, means marriage. So this is the difference between nullity and divorce. So when we move into Parsi law, so there is no ground for nullity with respect to a person with mental illness. But however, with regard to divorce, is similar to Hindu Marriage Act, that the person should be suffering from mental illness and not able to fulfill the obligation of the marriage for 2 or more years. So it's similar to Hindu marriage with respect to divorce, but there is no place for nullity of marriage with regard to unsoundness of mind. Now, when we look into the legal insanity, is different from the medical insanity. So it's just not just a mere presence of symptoms, but inability to manage affairs is essential. So here and there, slight deviation from normacy would not amount for the grounds. And as per the law, it's not just the giving the birth; it's the responsibility of the taking care of children and other marriage-related issues. So that is the obligation of the marriage. Now, looking into the one more aspect with regard to marriage is that Family Court Act of 1984, which was enacted to promote conciliation and secure speedy settlement of dispute in marriage and family affairs. Its jurisdiction is related to the validity, divorce, maintenance, custody, and adoptions. Usually, the proceedings are done with confidentiality under recordings, and legal experts can be taken, and free legal aid services for the weaker section, and counselors for reconciliation are being made provision under this act. So now look into the other aspect of adoption. Under Hindu Adoption and Maintenance Act of 56, those who are adopting and those who are giving up in adoption, both should be of a sound mind, and they should not be minor. And especially Hindu male, they should be taking consent from his partner unless she has been declared of unsound of mind. So it's same holds good for female and male. So there should be soundness of mind. So if there's unsoundness of mind prevailed, then they can't be taking in for adoption. Now moving into the very special management of property and affairs, which is being depicted in the Transfer of Property Act of 1982. Only person competent to contract is authorized to transfer property. So again here comes whether the able to competence to make a contract, whether there is a soundness of mind to understand what has been told and whether there is a rational decision is coming out of the person. So that is what important. So those families or alleged person suffering from mental illness, relatives can approach for court, where court can divert for expert opinion or assessment from the psychiatrist. That's where professional comes in the picture. So that's where they will be assessing and looking into the whether having psychiatric illness is of such degree that he is incapable of managing his property and affairs. So this further we will be discussing in this one, guardianship. So now coming on to guardianship, when we look into person with mental illness and guardianship, there are two laws which gives clear guidance. One is National Trust Act of 99, especially with autism and other developmental disorders. In Chapter 6, Section from 14 to 17, with appointment of guardianship or with removing of guardianship, their responsibilities, and also submission of report with regard to the responsibilities taken. And with regard to right of a person with disability 2016 Act, under Section 14, it provides a provision for limited guardianship. Person with disability who had been provided adequate and appropriate support but is unable to take legally binding decision may be provided further support of limited guardians to take legal binding decision on of his behalf in consultation with person. So this limited guardianship will be applicable like mutual understanding and coming to consistent with taking decision, and it will be applicable to a specific situation and in a specific scenario only. So it can't be generalized what you call decision. It should be a specific one. So these are the two which elaborate with regard to guardianship. Now coming into the final thing of my presentation, the civil right of voting. So when we look into the 1950 Representation of People Act, in section 16 subsection 2, disqualification for registration in an electoral law, it has been mentioned that a person shall be disqualified for registration in an electoral law if he is of unsound mind and stands so declared by the competent court. So it's not just that if he is of having a mental illness or unsound of mind, it also should be declared by a competent court. Then they will be not able to register in electoral law, so they can't vote or they can't stand for election. So with this, I would be like to summarize before I open session for questions and comments. So now, as we are aware that overall we looked into the medical laws, why is important, and differentiating between civil law and criminal law. Then we looked into tort law, intentional and unintentional. This one. Then we moved on to the interface between law and person with mental illness with 3 categories. And then we focused into the civil responsibilities with regard to testamentary capacity, marriage, then contract, consent, adoption, and even civil rights like voting. So overall, what would be like a professional would be called in here is that when there is assessment which is required so that they has a mental illness, and because of that mental illness, they are not able to take a rational decision. So looking into the unsoundness of mind, the professional will be called in. So that's where the interface mainly lies, especially with regard to civil responsibilities. So with this presentation, I would rest my presentation. So if there are no questions, I think we would end the session. I think as I heard from Dr. Chetan, for DNB students, this is an main questions for 10 marks, am I right? Being frequently asked either criminal responsibilities or the civil responsibilities which have been previously asked. So kindly prepare yourself for writing exam for 10 marks. With that, I wish all of you for good luck, all the best. Thank you.
Thank you, Dr. Vinay sir, for your presentation. We would also like to place our thanks to Unix Laboratories, through whose support through educational grant we are running this program.